4 months ago, a private individual petitioned the Civil Division of the High Court, challenging a new statutory instrument, which the Ministry of Energy had adopted. The statutory instrument gave the minister powers to appoint an executive director and the board of the Rural Electrification Agency, among other things.
The minister also now is given more powers to oversee the board, because in the old instrument, it was very weak, but I can now see the minister can take on a board member for abuse of office, inability to perform his or her function. That was very silent in the old.
Today, Justice Musa Sekana of the Civil Division of the High Court quashed the instrument in a 31-page ruling. One of the grounds given was that the Minister of Energy never consulted stakeholders, who include private sector in the public, when coming up with a statutory instrument.
The minister ignored the public, that is the people in the local government and also very other stakeholders that will be affected by this law. So in such a way, even when they passed it, it was not in the best interest of the public.
In the quashed instrument, the minister had excluded the permanent secretaries of the responsible ministries, such as local government, which was found to disable effective delivery of services.
The old board was full of PSCs. And you know, a PS who is very busy supervising a ministry to give him a very important institution may not have time. And given that the board has to take on the oversight function of REA, so these have also been taken care of.
The secretary to the Treasury, these are members that are should be part of the board, because this board is going to include use of money from the consolidation fund, and these are people who are supposed to account for it and budget for it.
Another ground on which court quashed the instrument was that the minister failed to furnish court with evidence that the instrument was approved by cabinet.
It is improper in procedure and therefore wrong to pass such a law that will affect the general public, and also because it has effects on the consolidation fund. So the approval of the cabinet is really important.
In normal practice, after wide consultation on the new instrument, the minister is supposed to table it before cabinet for approval. However, the new ruling has various implications on the businesses undertaken by the agency under the quashed instrument.
Anything that was done after the gazettement of the instrument is null and void, and this has financial ramifications on the agency. For instance, people who entered into contracts with the agency under the instrument, we may bring claims against it or against government.
Furthermore, the ruling will also bear administrative and political implications.
It discredits the ministry, the line ministry, in respect to the funders. The agency which is affected has to find a way of amending its management, its structure, especially in regard to the board which had been set up under that instrument.
In a nutshell, the new instrument governing Rural Electrification Agency has been quashed by court, and therefore the line ministry, that is Ministry of Energy, can appeal this ruling through the Attorney General within 14 days. Sudil Biarhanga, NTV.